Fourth oral question, Baroness Ludford.
I beg leave to ask a question standing in my name on the order paper.
My Lords, the Government is considering the draft updated code, and if the decision is taken to approve it, the Minister will lay it before Parliament. Parliament will then have 40 sitting days to consider the code when it is laid. It is important that the correct process for laying the code is followed.
Minister for that answer, but the Equality and Human Rights Commission has today had to write to the Minister for Women and Equalities, reminding her that it is 6 months since the Supreme Court judgment, which confirmed that sex in the Equality Act means biological sex, and 6 weeks since the Commission submitted its draft of the new Code of Practice for implementation of a judgment that the Home Secretary reportedly regards as beyond reproach. Does the Minister think it satisfactory that the pitfalls of delay in producing the statutory guidance include that service providers continue to rely on the existing 2011 code, which is now partly illegal and must be quickly revoked and replaced, and that many organisations continue to drag their feet, wrongly claiming that they need to wait for the code and risk breaking the law in their treatment of women and same-sex attracted people?
The code is absolutely important, and that's why it needs to be dealt with properly and appropriately. And of course, the code was submitted, the draft code, on the 4th of September, over 300 pages long. And actually, it's really important that the government consider this across Whitehall. But we're also committed to ensure that the process, we have a duty, as specified in the Equality Act, to consult the devolved administrations too. So I don't think the timescale that the noble lady is talking about is a delayed process. It's absolutely important that we ensure that the application of the Supreme Court ruling is properly applied in the draft Code of Conduct, which is what we will ensure is done properly.
My lords, can my noble friend, the Minister, confirm that 6 weeks, which included the summer, is actually not a very long time? And does my noble friend agree that the crucial matter here, of course, is to ensure that the guidance is right? It respects the dignity and rights of individuals and groups. It places an equality duty on public bodies and businesses in scope with our legislation, and it ensures that legal challenges are avoided by not rushing into this matter, by being bullied by the EHRC editorials in the Times and others.
Well, I think my noble friend is right, and as the chair of the Equality and Human Rights Commission acknowledges in her letter, and she's in her place, it is important that the Secretary of State can take a fully informed decision. That's also why, although the letter was received today, officials have approached the Equality and Human Rights Commission requesting additional material, that this needs to be reviewed as part of giving a thorough consideration of the code. This was acknowledged in today's letter, that this request for additional information is necessary. We have not, obviously, received this information from the EHRC.
To agree that it is highly desirable that the guidance or the codes of practice, when published, should be as sensitive as possible about the needs and interests of those individuals who have, by long usage or certification, acquired a gender different from that of their birth gender.
Well, I think, as the noble Lord acknowledges, we have a duty under the Equality Act to ensure equality of treatment, and that includes trans people and others. And I think it's really important that that is understood. And also I would make the point that in terms of the Equality Act, it does remain in place, and providers should continue to follow the law. Practically, this does mean providers should consider the needs of all of their service users when designing and delivering services. And if they are uncertain as to how the to apply the Equality Act to their specific services, then they should obtain legal advice.
My Lords, I serve on the UK delegation to the Council of Europe Parliamentary Assembly, and I've not had any dealings with the Commissioner on human rights. But is the Minister aware that yesterday he shared his observations that inconsistencies between the Equality Act and the Gender Recognition Act could leave some trans people in an intermediate zone, a problem that was identified in 2001 that led to the Gender Recognition Act? How will His Majesty's Government ensure the Code of Practice prevents that discrepancy?
Well, can I say to the noble lady, I do understand that there are many trans people may have read the UN human rights experts or the Commissioner of Human Rights correspondence. I reread it this morning. And it will raise, undoubtedly, concern amongst trans people. And we've been clear that the laws to protect trans people from discrimination and harassment will remain in place. Trans people will still be protected on the basis of gender reassignment, a protected characteristic within the Equality Act.
According to the Equality and Human Rights Commission, the government received their full revised Code of Practice on the 4th of April. Only 3 chapters of it were altered in the updated version following the Supreme Court ruling. Can the noble Lord the Minister explain why there has been such a delay to review only 3 chapters and how much longer they expect it to take?
Well, I don't accept the noble lady's assertion. The department received the final draft code on the 4th of September, 300 pages long. That code needs detailed consideration because, as my noble friend pointed out, we want to avoid uncertainty. We want to ensure, as the Equality and Human Rights Commission is absolutely concerned to ensure, that there is absolute clarity on the Supreme Court decision. That's why we will take the necessary time to ensure that when it is presented to Parliament and have full consideration by Parliament, it is as accurate and legal proof as possible. There has been no delay.
My Lords, given the gross misrepresentation,
Sorry.
Keep going.
Can the noble Lord the Minister indicate how the government plans to monitor future case law in this area to ensure that statutory codes remain accurate and up to date, particularly if the courts further clarify the relationship between sex and gender reassignment under the Equality Act?
Well, I mean, put simply, that's why we have the Equality and Human Rights Commission, and that's why they have an independent responsibility from government to do precisely that. And that's why we will give full and proper consideration to their draft code. And it's important that we maintain that balance and understand our respective roles and responsibilities under the Equality Act.
My Lords, my Lords,
Right, we'll have my noble friend, and then we'll have Baroness Falkner. Be brief.
My Lords, given the gross misrepresentation of trans people as a threat to others, I urge the noble Lord the Minister to encourage the government to take all the time that is necessary to get the guidelines absolutely right, so that we can reverse the uncertainty created by the Supreme Court and the subsequent misrepresentation of that judgment. Furthermore, I urge the government to urgently address the Equality Act to ensure that trans people maintain the protections that they have within the legislation.
I think my noble friend is absolutely right, and of course we recognise the application of the Supreme Court ruling is in some settings complex, and it is really important. That's why this code is given full and proper consideration. That is why the independent EHRC Code of Practice is so important, and we will do that. I will allow the noble lady to intervene at this late stage.
My Lords, I have enormous respect for the Minister, and he's given very fulsome answers today. He did refer to me. Therefore, I'd just like to clarify for the House, because I know the Minister would not wish to mislead the House, that the time period needed for the code to be laid in Parliament is not 40 sitting days, it is 40 days, 40 calendar days, Section 15 of the Equality Act. And the further point that I would want to clarify is that we were asked to provide the Equality Impact Assessment last Friday. We provided it to the Government on Monday. We're here to serve the Government with any information that it needs at pace.
Well, and listen, I have, as she knows, the huge respect for her and the responsibilities she has, and it's a very serious responsibility. And I think as her letter to the Secretary of State today and the debate that we've had this afternoon, it is very clear that we have to consider this matter seriously and take into account all possible risks and issues to ensure that we do have a legally proofed code that is understood by everyone in respect to their responsibilities under the Equality Act. In respect to the 40 days, I must admit, my briefing does say 40 sitting days, but I'm prepared to be corrected, so thank you.
My Lords,